move all my things into that office and use that during the time that I'm pumping. That's I think a reasonable request. Your employer might come back to you and say, you know what, we don't want you to move your workspace. We think that will be disruptive, but there is an empty conference room, and, we're proposing that every time you need to take a break, you're going to go use the conference room, and you can lock the door and put a sign on it or whatever. And so, that's then, once your employer gives you that alternative, you then really need to have a conversation with your employer about, is this alternative adequate? Are there reasons why it's going to be more disruptive or harmful to you to have to, move to a different room every time you need a break, or why other people are going to be barging into the conference room or something like that? It's really it's going to depend a lot on your individual situation. And the idea is that you and your employer have to kind of work together to figure out what is going to be the best solution for you and your employer. And again, if there are reasons why the alternative that your employer suggests isn't going to work for you, you need to bring those up and discuss those with your employer. Under the law, the employer cannot force you to accept any accommodation that you didn't ask for and that you don't want. So in this scenario, the employer cannot force you to use the conference room to pump in, for example, if that's not what you asked for, that's not what you want to do. But that also doesn't mean that you can force them to let you, have this other accommodation, move your desk or something like that. So, you just kind of have to work together to try and come to an agreement. You can change your request, you can make new requests, and also as sort of a last resort, if your employer says, whatever it is that you're asking is going to create an undue hardship, you can provide your own accommodation at your own expense if it's not going to unduly disrupt the employer or the work environment. And this really should be a sort of last resort where you've had this conversation with your employer and they really can't provide you with the accommodation that you're looking for. I'm not sure what a great example is in the pumping context, but it might include something like, maybe you want to buy your own mini fridge to store your breast milk in, because you'd rather not use the office fridge or something like that. You could do that, or you could imagine a situation where if you're working at like a construction site or somewhere that is just so dirty that even though your employer is really trying to find you a good place, clean, private place to pump, you say, you know what, I'd rather just pump in my car or something like that. Your employer can't punish you for taking your own initiative and coming up with your own accommodation at your own expense if there's really, if anything that you're proposing is going to cause an undue hardship to the employer. Under the law, the Illinois law also limits the situations in which an employer can ask for a doctor's note. This is usually more applicable in situations that involve like pregnancy and light duty accommodations, but it may be that your employer might ask for a doctor's note relating to, the fact that you are pregnant or giving birth and are planning on breastfeeding. Generally, they can probably ask you for that kind of note. They could ask that note includes sort of your estimate of how long you're planning on breastfeeding, but that doesn't mean that if you decide to breastfeed for longer, couldn't, come back and ask for, and tell them that, or even, go back to your health provider and get another note if your employer is really pushing for that kind of documentation. It's also possible that if you, for some reason, need more or longer breaks to pump or you anticipate that you might need longer breaks to pump than what is sort of considered typical, which we'll get into, your employer might come back and ask you for a healthcare provider note. This is, it's going to depend a lot on your individual situation, but the law does sort of limit the situations in which an employer can ask you for a doctor's note. They can't just do it to make your life more difficult. There really needs to be some kind of job-related reason why they need the note. So this is sort of the overview of what the Illinois Human Rights Act, which is kind of the broadest Illinois law that applies to pregnancy accommodations in employment. And just to kind of quickly review what the responsibilities are, again, employers have to give reasonable accommodations for pregnancy conditions, and that includes lactating, unless that accommodation is going to create an undue hardship. The employer has to have this timely, good faith, and meaningful conversation when somebody asks for accommodation. And then in some situations, they can request a healthcare provider's note, as we've talked about, and the employer can also suggest these alternatives, and that becomes part of the conversation as well. Again, the employer cannot retaliate against you just for asking for an accommodation, or force you to accept an accommodation which you didn't ask for and which you don't want. And then, as an individual, you also have some requirements, some duties under the law. You need to inform your employer of your pregnancy condition, in this case, that you're planning on breastfeeding and are going to need those accommodations. You also have to cooperate in this conversation in good faith to try and figure out what the accommodations are going to be. And if your employer is appropriately requesting a doctor's or a healthcare provider's note, it is your obligation to comply with that. So then we've talked about kind of some of the legal requirements. Moving to sort of how you can use those or think about those in actually having your conversation with your employer, and thinking about tips or pointers that maybe aren't necessarily required under the law, but that you want to keep in mind. To prepare for this conversation with your employer about pumping at work, the first thing you want to do is research your employer's policies. If your employer has a lactation support program or a lactation policy or any kind of lactation room, anything like that, you ideally probably want to know about that even before you have a formal conversation with your employer. If there are policies that you have to follow in requesting accommodations, it is important to follow those policies. There's a court in Iowa, a court case in Iowa, that dismissed a case brought by a woman who was who challenged the fact that her employer had basically denied her access to the lactation room. She came back, on her first day at work, and they said, well, you haven't applied for access to the lactation room, and that takes 3 days to process. And so even though she was standing there, basically leaking and saying, I need access now, I can't wait 3 days. The court basically said, well, you should have followed the policies. And even though that was a little bit, I would argue, unreasonable, it's important. It's important to follow any policies that your employer has, so that you don't end up in that kind of situation. And again, to that point, you also want to think about the timing of the conversation. The law does not say anything about when you need to have this conversation with your employer. You under the law could certainly wait until your first day back at work to ask for accommodations. But, again, going back to the fact that, it's about reasonable accommodations and undue hardship, you really want to have this conversation well in advance of when you're needing the accommodations to give your employer that notice, to give them time, particularly if you're going to need a partition or a curtain put up, if you're going to need to move space, if there's going to be scheduling changes that need to be made. In general, the more advance notice you can give your employer, the better, and the better argument that you have then that it's reasonable for them to accommodate you because they have plenty of time to figure it out. Other things to think about, depending on your employer, your supervisor, think about whether you want to ask these questions or make your initial request in person or in writing. It doesn't matter under the law how you make that request. Different people are comfortable may or may not be comfortable having that conversation in person versus in writing. And you want to plan out what you want to discuss. And the big three things that you want to discuss are what is this space that you're going to use for pumping? It needs to be private, it needs to be clean. How are breaks going to work? And also, even though the law doesn't really get into this in much detail, you want to discuss where you're going to store your breast milk. And then you also want to plan, during this conversation, you want to be listening really carefully. You want to take really detailed notes of what's said during the conversation. And you may want to, if this is an in-person conversation, follow up with an email or a letter that says, this is my understanding of what we discussed. This is my understanding of how, particularly of what the space is that I'm going to use, how the breaks are going to work, where I'm going to store my breast milk. And again, that's not something that you need to do under the law, but it may be helpful depending on your employer and your individual situation. So to get into these kind of specific topics in your conversation with your employer about accommodations, so the first thing is, what is the space that you're going to use for pumping? And as I've mentioned, under the law in Illinois, it cannot be a bathroom or a toilet stall. And I guess again, this all comes back to what is reasonable and what's going to pose an undue hardship. But the law is pretty clear, I would say, that, it's almost never going to be a bathroom or a toilet stall. There's a little bit of wiggle room about if it's a locker room that's also a bathroom, as long as if there are places to sit and there's a lock, and it's not just a toilet stall, maybe that is going to be okay. And again, it's going to depend on what else there is available and sort of, what else the employer can offer you. It has to be private, which means generally that either that there's a lock on the door or that there's some kind of system of putting up a sign, and making sure that people aren't going to be walking in and out. It needs to be shielded from view, so if there's a window, there needs to be a curtain or, paper over the window or something. And again, it needs to be free from intrusions by coworkers and the public. People aren't going to be just walking in and out. There needs to be enough space for a chair and a flat surface for a pump. That can be a relatively small space, depending on how much room your employer has. And it can be, it can be a temporary space or it could be a shared space, as long as it's available to you and you're able to make it private when you need to use it. And then some other things that are recommended and I think are certainly reasonable things to request and maybe reasonable things for your employer to provide, but are not necessarily something that the law is clear that your employer must do. Things like an electrical outlet, access to a sink or running water, access to a refrigerator, and the law does require that the employer try and make it near your work area, so that you're not, not taking long periods of time to get back and forth when you need to pump. And just one other note going to this access to the refrigerator. So in terms of interpreting these laws, they talk more about space for pumping, and at least the federal government has said that they interpret space to store your breast milk as part of the requirements they give you, that your employer give you space for pumping, but none of these laws are very specific about what kind of storage space that is. So it might be, that's going to depend a lot on your employer, whether they're going to say, you can just use the office refrigerator, whether they're going to say, bring a cooler to work, or, provide you with a refrigerator. That needs to be part of your conversation with the employer. It's not really clear what the legal guidelines are, and that's going to depend sort of on their resources and your job in the space. So moving to talking about breaks, and the law entitles you to reasonable breaks for pumping. in terms of what's considered quote unquote typical, the guideline is usually 2 to 3 times for an 8-hour workday, and usually to anticipate that will take about 15 to 20 minutes per session.